Welcome to the Judicial Research and Training Institute of Korea. We would like to take a few minutes to introduce you to the basic stages of the Korean civil litigation system. Civil litigation involves matters brought to the court to resolve the legal disputes concerning the rights of the parties or the legal relationship between the parties. The Korean civil law system aims to provide fair and speedy trials. Our judiciary is also committed to ensuring efficient proceedings. Civil actions in Korea are commenced when the plaintiff files a complaint with the court. Once the complaint is filed, the court will review the complaint, then immediately proceed to have a copy of the complaint be served on the defendant. After this service of process, the defendant has 30 days from the date of being served to file an answer. When the complaint cannot be served, the court will issue an address correction order, and in some cases, service by public notification is also possible through the court's order. Also, the service by public notification and related motions for evidence must be completed prior to the hearing date. Then the first hearing is scheduled immediately afterwards. For those cases where the complaint is served on the defendant, the judge reviews the case records immediately after the deadline for filing defendant's answer. The judge can then decide on how the case should proceed. Subsequent case proceedings at this stage of the case will mostly depend on whether the defendant has submitted a written answer to the plaintiff's complaint. When a timely answer has not been filed, or when defendant's answer includes admissions of the allegations, then the judge may render a judgment without holding a hearing. But if the defendant submits a timely answer and denies the plaintiff's allegations, the judge will review the relevant case records, classify the case, and then decide how the case should proceed. In order to allow the parties to have the opportunity to meet the judge face to face, the judge is to set the earliest possible date for the first hearing. Here, the first hearing is a procedure that is primarily oral in nature and conducted before a judge. In this proceeding, each party or the party's counsel identifies the disputed issues of the case and has the opportunity to rebut the counterparty's arguments. The hearing permits the parties with an opportunity to make sufficient arguments about the case, and by holding the hearing in an open court, it also guarantees the court's fairness of the case. Once the parties' disputes is clearly identified through the first hearing, motions on evidence and examination is limited to those issues acknowledged in the first hearing. Then after the case is classified or the first hearing is completed, a separate procedure can occur if the case or the evidentiary issues in the case are complex. For these cases, the judge may determine to clarify the claims and evidence of the case and decide to send the case to a separate procedure to prepare for the trial. The preliminary procedures may involve the parties submitting and exchanging written briefs, or the procedure may involve identifying the parties' claims and evidence in court. During the proceedings of the hearings, both parties must make their arguments through written legal briefs and must make requests for admissibility and submit evidence before the end of this procedure. This means that any relevant documentary evidence should be submitted by attaching it with the legal briefs. Other motions, such as requesting written documents, conducting fact verification process, applications, and requests to examine and assess the case evidence, and motions to request to summon witness, must all be completed at this stage. On the day of the evidence examination, an extensive examination of the parties, individuals subject to examination, and the parties' witnesses is carried out. In order to do this, these persons are required to appear in court on day for the evidence examination. Once this procedure is done, the court is to render a judgment within a short period of time. Civil lawsuits in Korea begin at the district court level. The district court is a first-tier court and has jurisdiction over broad matters. For cases involving land, the district court of the defendant's domicile has the jurisdiction over the case. For other real property cases, the plaintiff may bring the case to the district court where the real property is located. And if the case involves torts, then the case may be brought to the district court at the place of the occurrence of the legal activity. However, the parties may also agree to subject themselves to a different district court through mutual agreements. The district court cases can be handled by either a panel consisting of 3 judges or by a single panel judge. Whether the 3-judge panel or a single panel judge will hear the case depends on the amount in controversy. If the amount exceeds 200 million Korean won, then a 3-judge panel will hear the case. And if the amount is less than 200 million Korean won, then a single panel judge will hear the case. We will now visit an actual courtroom. This is where the deputy clerk sits. The deputy clerk assists the judge by managing the overall court proceedings, and he or she also keeps an official record of the case as well. This is where the assistant clerk is seated. Their main responsibilities are to maintain the case records, serve documents to the parties, and summon the parties and the witnesses. Finally, this is where the court report is located. The reporter's deputy is to keep a verbatim transcript of the testimony given by a party or a witness. And this is a seat for the bailiff, who maintains the order of the courtroom during the court proceedings. There are several principles followed in the civil proceedings of the Korean legal system. One of the principles followed is the principle of disposition. Under this principle, the court is prohibited from rendering any judgment on matters that the parties did not claim. Instead, the parties are to decide on the initiation of the action, what the disputed matter is, and when to end the dispute. Another principle followed in the civil proceedings is the principle of pleading. This principle implies that the decisions should be made based on the materials that were submitted to the court. So, based on this principle, the parties bear the responsibility to collect and submit the evidence for the case. The Korean civil proceedings also upholds the principle of oral arguments. Under this principle, the parties are entitled to present their arguments and evidence orally rather than through the use of documentations. Other principles followed in the civil proceedings include principle of directness, mutuality, public trial, timely presentation, and extensive examination principle. Due to the fact that the Korean legal system has yet to implement the jury system for civil cases, the Korean judges must take on the role as fact-finders for the case. While the burden of proof generally lies with the plaintiff, there are some instances when the burden shifts to the defendant. The plaintiff has the burden to present sufficient evidence for all elements of the claim. If the plaintiff has presented evidence for each element of its claim, then a defendant must present rebutting evidence to counter plaintiff's claim. Here, determining who has the burden is crucial since it often plays a key factor on the outcome of the case. After closing of the arguments, it is now the court's turn to render a decision. The written decision of the court typically includes the holding of the case and the court's reasoning for reaching such a decision. It is customary in Korea for the court to provide a detailed reasoning of the decision. This ensures that the parties understand the court's decision more clearly and helps the parties to accept the final outcome of the case. While the court's decision can be enforced after the judgment has been finalized, provisional execution of the court's judgment allows the judgment to be enforced prior to the entry of the judgment. For those parties not willing to accept the court's decision or the fact-finding of the court can take action to make an appeal. If the party decides to make an appeal, filing must be made within 2 weeks from the day of the court's decision was served on the party. In Korea, appeals are generally handled in the high courts. However, when the amount in controversy does not exceed 200 million Korean won, then a single judge panel working in the appellate division of the district court will decide the matter. Overall, the appeals proceedings are very similar to the trial proceedings, and the parties are given the opportunity to present new allegations or evidence at this level. However, we are seeing some new changes since the Korean judiciary is placing more importance on conducting full exhaustive hearings at the trial level and in-depth evidence examination. Any party unwilling to accept the rendered decision by the appellate courts may make an appeal to the Supreme Court of Korea. The Supreme Court is the court of the last resort, and the court's decision of the case becomes final. If a party decides to make an appeal, it should be made within 2 weeks from the day the court's decision was served on the party. When the Supreme Court reviews the case, it will limit itself to reviewing issues concerning matters of law. Therefore, the parties may only appeal those cases that the appellate court erred in concluding the issues of law, or when the court committed grave errors in law. As mentioned, the appellate courts can review both factual and legal issues, but the Supreme Court may only review legal issues of the case. When a valid and final judgment is entered by the court on a particular case, the court's judgment has a binding effect on the parties. If a similar dispute arises on a same matter, then the parties are precluded from relitigating the matter. This is because the final judgment of the court has a res judicata effect that permits legal stability to the court system and precludes repetition of litigation on the same matter. A retrial involves requests for a new trial after the court has entered a final decision on a case. Requests for a retrial is made to the court that issued the judgment. Retrials is a court process that ensures the soundness of the court's decision. Grounds for retrials are very limited. For example, retrials may be permitted if the counsel made decisions regarding the legal proceedings regardless of the intent of the client, when the court admitted falsified documents as evidence, or when a complaint was filed with the incorrect address of the other party. Alternative dispute resolution, which is also commonly known as ADR, plays a crucial role in resolving civil disputes in Korea. In mediation, a third party is involved with the resolution of the dispute who facilitates to help the parties reach a settlement. Within the Korean courts, we have experts and those recognized in the field appointed as mediators to encourage settlement by using the process. These mediators are appointed and organized into a mediation committee. Over the years, the Korean judiciary has promoted utilizing mediation as a means to resolve disputes, and thanks to the continuous efforts by the Korean courts, we have seen an increase of the number of cases resolved through mediation. Another means of settling disputes outside of the courtroom is available through conciliation. Conciliation involves the parties settling disputes by reconciling certain aspects of the disputes to reach a resolution. Depending on the stage of the civil proceedings, various forms of conciliation can take place, including conciliation before filing a complaint, recommendation for conciliation by ruling during a trial. In arbitration, a neutral third party serves the role as a decision maker and decides on the disputed issues. The parties agree to have the decision of the arbitrator as binding, which is similar to a court's final judgment. Professional arbitration bodies such as the Korean Commercial Arbitration Board and the Seoul International Dispute Resolution Center generally conduct arbitrations in Korea. The court can also be involved in the arbitration process by ensuring enforcement of the arbitration judgment. Perhaps the most prominent change in the Korean civil proceedings is the adoption of the electronic filing system to the court system. With the system, the parties are able to file the case and legal documents electronically and provide access to the case and documents online. This means that the other party will be served with an electronic copy of the case documents by accessing the court's electronic filing system webpage. In addition, electronic copies of the case documents are used in the hearings and for examining evidence. The advantage of using the electronic system is that it enhances the overall efficiency of the judicial system and allows a more reliable hearing procedure. Throughout the years, our judiciary has worked hard in developing and maintaining efficiency across the civil litigation system. We, at the Judiciary of the Republic of Korea, will remain committed to ensuring the public trust and establishing a judicial system that is both transparent and efficient.